Welcome, everyone, to our Zugler and Friends Women and Money Talk series. This is I don't know, number 12 maybe in this long series. We've been doing this now for over a year, which is crazy. And my partner, Terry, can't join us today, so we miss her a lot, but she is sending us well wishes, and she's excited to hear how this goes. But I am going to introduce a new topic to us today, and we have an expert with us, Lizzie Hollis, from Freestone Capital, here to kind of walk us through it. And the topic is estate planning. So most of us are juggling big changes in our lives right now, and this topic just feels either unimportant or too intimidating, kind of difficult to engage with. But it's probably one of the most important things that we can do. And, taking care of something like this allows us to live our lives more fully and make us feel more in control of what's happening. So, ultimately, it's about protecting ourselves and our loved ones. And it seems like this topic sometimes feels like it's just for the super rich. Like, oh, I'll just go through the regular will process, or, oh, my state has decent laws, I'll just do whatever my state does, right? But getting a handle on this right now can actually play a big part in your overall financial plan, even your living financial plan, right? So we're going to talk to Lizzie all about that. So just a quick intro on Lizzie, and just so that you can start to think about what kinds of questions you'd ask her. Lizzie Hollis brings over 10 years of experience as a wealth and estate planner and is currently the managing director and a wealth strategist at Freestone Capital, specializing in wealth and estate planning. And prior to joining Freestone, she practiced at a boutique law firm, advising high net worth individuals and families in all phases of estate planning, including trust administration, gift generations, skipping tax planning, business succession planning, and charitable planned giving. So she's very experienced in this topic. And when I approached Lizzie about doing this, she was like, yes, anything to support women feeling more confident about, what they're doing with their money, how they're handling their money. So I have to do a disclaimer before we get into the weeds of it, right? Which is, this is not advice. These talks are meant to educate you, and this is really more of a thought starter for you, right? So I'm assuming that you're here because this conversation and topic is pretty new to you, and this is just some stuff to get your mind turning. Lizzie actually resides in California. She's aware of laws in other places, and kind of like the rumored, oh, it's actually really difficult in this state, or it's probably easier in that state, right? Like, she knows things like that. But I think, we're scattered all across the US. It's really important that you use what you're learning today to start to understand how this works in your state. So I've gone ahead and pinned the warm-up questions in the chat. It's just helpful for us to kind of know, where are you starting from on a scale of 1 to 10 about estate planning, right? Do you feel really good about where you are? Are you, starting from 0 and you really need to learn fully what this is about? And I am curious, what is one thing? I see lots of 2s and 1s. Woo! All right, this is going to be a fun one. And I am really curious to know just what is really one thing that would be really helpful for you coming out of this conversation. And just feel free to add that as it comes to you. It doesn't need to be perfect. So as always, I kind of get started with some questions just to get the ideas going, and then feel free to interrupt at any time if you have a question. Again, this is your time, and if you're spending an hour to be here to learn, then again, I want to make sure that you get everything that you want out of this conversation. So please do take advantage. Okay. So Lizzie, that was a lot of talking on my part. It's so great to have you. Thank you for being here.
I'm so pleased to be here. What Stephanie was saying when she asked if I wanted to join, I said yes. I'm normally not a great public speaker, so just bear with me. But I think this is such an important topic, topic, especially for women. So I'm so happy to be here and discuss this with you guys.
Thank you for being here. So we'll go ahead and just start off with some foundational questions just to get people oriented. So I think like some of the things I was hearing early on when I told people that we were doing this talk was they're like, well, I don't know, I don't have enough assets, or I'm too young for this conversation, right? I'd love if you could just start by giving us a quick explainer on what estate planning actually is and why someone in their 30s or 40s or even 50s, right, should care about this.
Yeah, absolutely. So an estate plan essentially explains who's going to be in charge if you were incapacitated or pass away. It appoints individuals, they're called fiduciaries, to manage your financial assets, manage your healthcare decisions, anything like that. And then it dictates how assets are ultimately distributed when you pass away. So when we think about it, we look at your total estate, and your total estate is your liquid assets. So brokerage accounts, cash accounts, anything like that. And then your non-liquid assets, so business interests, real property, anything like that. And when you work with an attorney, what you're really doing is you're going to figure out your total estate, and then they make suggestions based on what you have to determine the best estate plan for you. I think what is the most foundational or most important documents as it relates to this would be setting up a will and a power of attorney and for finance. And then depending on what state you're in, it's either a power of attorney for healthcare or an advanced healthcare directive. It just depends where you're living. But those can be incredibly important. And then you just kind of build up from there based on what you have. I also, just to your point about people in their 30s or 40s, you may not think you have a large estate or an estate really, but you do. For example, in California, if your estate is above, it's roughly 208,000, then your estate could potentially be subject to probate. And probate, for those that don't know, is a court administration of your estate. Essentially says someone's going to appoint themselves to be the administrator of your estate. They're going to go to court and they're going to say, Judge, this person passed away and we need to collect their assets and distribute them based on whether they have a will, or if they don't have a will, based on the laws of the state that you're living in. Most of us may want to have control over where those assets go. You may not want to rely on what the laws of the state you're living in say. For example, in California, if you're married, we're in a community property state. So if you're married, any community property assets go to your surviving spouse if you don't have an estate plan. And then any separate property assets are split depending on who's then living between your kids and your spouse, or your parents and your spouse. And that might not be your plan. So those are things that, having an estate plan will help dictate what you really want. Your wishes are going to be respected. The other thing is you don't get to control your future as much as I try to control everything I can. So having fiduciary, so an agent under a power of attorney, executor under a will, if you have a trust, a trustee of your trust, and agent for healthcare decision-making powers. If you're incapacitated, you have people in place that you trust who's going to manage those assets while you're incapacitated or you pass away. It's something that's particularly important if you have kids is naming guardians. So ensuring that you have the right people in place to step in should something happen to you to take care of your children. So those are things, even if you don't have a large estate, you still want to make sure that your wishes are followed and that you have the right people in place.
Wills versus trusts, right? I think we hear these terms thrown out a lot. Are they interchangeable? Are they different? How do I know if I'm a good candidate for, say, a trust? How would a will be executed, for example?
I think, all right, going over the basic estate planning documents. You have a power of attorney for finance. That is someone, you're going to name someone, and it's called an agent or attorney in fact, who's going to make financial decisions on your behalf if you're unable to do so. They can do day-to-day checking, file your income tax return, whatever powers you have, sell your property if needed, whatever powers you put in there, they can take care of those. Then you have your advanced healthcare directive or power of attorney. Those are pretty for healthcare. That's pretty self-explanatory. You appoint an agent to make healthcare decisions for you if you're unable to do so. The real meat and potatoes, so to speak, of estate planning are either a will or a trust. If you have a will, it will outline who the executor or personal representative who's going to manage your estate when you pass away. And it's going to dictate how assets are ultimately distributed. Now, if you have a will, because all the assets are still in your name, that will is subject to probate. So whoever is appointed as executor will have to go to court and, go through that probate process I was talking about earlier. If you have a revocable trust, then you avoid the probate process, because essentially what you're doing is you're establishing a revocable trust, which is kind of can be difficult to explain, but it's like a legal vehicle that you are the trustor or grantor. There's many names. We like to use a lot of synonyms here. And you're the creator of the trust, and you're also the trustee. So you're the manager of the trust. During your lifetime, you're the beneficiary. So you create this trust that says, during my lifetime, I'm in charge and I'm the beneficiary. If something were to happen to me, if I'm incapacitated, I name so-and-so as my successor trustee. And on my passing, assets are going to be distributed as follows. Now, the beauty of a revocable trust is that assets that are held in that trust avoid probate, because you don't own them. The revocable trust owns them. So therefore, they're not subject to probate. I think it just depends on what state you're living in and what makes sense. So, for example, in California, the probate process here isn't fun. It can take a very long time, and the courts are really impacted. We have high probate fees. And so setting up a revocable trust often makes the most sense. I work with clients in Washington and Oregon, and their probate process is far simpler than California. And so sometimes it makes sense to just do a will and keep things simple. Just like by way of example, in California, it can take up to 4 months to appoint someone, to get a court date to appoint someone to become the executor approved by the court and to open probate. In Washington, it can take a week. So that kind of gives you some idea of, the differences between states. Sometimes, I've heard New York isn't great for probate too. So that is also a state where I often see clients of Freestone who they set up a revocable trust just because they don't want their family to have to go through that probate process.
Got it. Wow. Yeah. I mean, it seems like, and it sounds like, you and I kind of chatted about this, Lizzie. The probate process you mentioned, like for in California, for example, can take just 4 months just to get started.
Yes. I think I shared this with you before. I practiced for a number of years before coming in-house at Freestone. And the last probate I did right before I moved in-house it was just one house. The father had one house that he didn't actually transfer to his trust, and we couldn't really work around it. So we had to go through probate for this property. And it took almost 2 years to transfer this property to the beneficiaries and close probate, because the courts are just so impacted. And it should have been basic. It should have been a very simple process. But, we don't control how many people are passing away, how many probates a court has. And so it can make it really, really difficult. And if you think about it, the family's grieving. The family, your family is already going through the grieving process. Having to kind of drag that out it's not fun sometimes.
Right. And also, I mean, this happened to a family friend recently. Tell me a little bit about like this. Like there was a situation, it seems, where someone passed and his family actually didn't agree with his will.
Oh,
And there seemed to be some contesting of the will. Can you say a little bit more about that?
yeah. So, and again, I want to qualify, every state's different. So,
Right.
but it can be helpful to have an estate plan for this purpose to dictate where you want assets to go. Sometimes beneficiaries don't like what you say in your will. And so they may contest the terms of the will, and often they'll argue undue influence, or that the individual didn't have capacity, anything like that. It can be hard to prove that. And you run the risk of the no contest clause, which wills often have, where it says you don't get your share of the estate if you contest the terms of the will or the trust or whatnot. Now, if you've cut out someone out of the will, then they have nothing to lose, right? Because they're not going to get anything anyways. But it can be really unfortunate because it gets expensive very quickly when someone's contesting a will or a trust. It's unfortunate. And often, money changes people, as I'm sure you guys have seen. You may have had a matriarch or patriarch and they pass away, and then all of a sudden, all sorts of stories come out of unresolved issues, and people don't like what the will or trust says, and you're working through all of that, and it can be difficult. So having an estate plan that's very clear cut, and especially when you're in your 30s and 40s where you have capacity, can be a good thing.
Yeah. This is going to be a little bit of a left field question, Lizzie. I didn't prep you on this one.
It's okay.
Someone recently told me about something called a holographic will. Is that right? Can you tell us a little bit, what is a holographic will exactly, and how does that work?
It's basically a handwritten will. You set forth in your holographic will, a handwritten one, where you want assets to go. You don't usually see that when you have an attorney. It's someone who, you often see it where someone doesn't have an estate plan and they're going on an amazing vacation where there might be something that, there's a slight chance of danger. And so they write something down and say, if I pass away, I want my assets to go to so-and-so. When I practiced, I once probated a holographic will that was written on the back of a receipt, and that was considered valid. And so you just never know. But I've suggested to people, if they can't get in to see their attorney, just putting something together. That way, should something happen, their wishes are going to be hopefully respected.
Yeah, but I found that so funny that people, it's almost like an urban legend that this is possible, and to learn that this was almost the most irrefutable. And you correct me, you are the attorney here, right? Like it seemed like this was the most like irrefutable form of a will. It's like pen and paper on a napkin, to your point, on a receipt.
Yeah.
I mean, it was just sort of mind-boggling.
And it still works. Yeah,
it still works.
It's wild. Submitting that receipt to the court felt a little silly, but it was respected. Luckily there wasn't anyone contesting it. But the court said, yeah, that's their will.
I'm not trying to say that anyone should do that. I think that it's a little risky, but it was just funny. I had learned about that recently, and I was like, wait, what? This is hilarious.
Yeah.
Okay. Well, so you were talking about just now revocable trusts. I know there are also irrevocable trusts. Can you tell us a little bit about that? And I don't know if there are any other benefits to these kinds of trusts other than just in death, how things are handled?
Sure. So irrevocable trust, typically you set up an irrevocable trust, which is a trust that is irrevocable. You can't change it. You can't modify it. And you typically set it up for someone else's benefit. Or you may receive and be a beneficiary of a trust that someone created for your benefit, and it's an irrevocable trust. The benefits of the irrevocable trust are, the provisions are kind of locked in. You really can't change them. And there's pros and cons to that. Let's say I've dealt with clients who set up irrevocable trust for their kids. And the irrevocable trust says, oh, everything goes to them at age 30. And then their kids get older and they're like, oh, I wish I would have kept it in trust longer. It's hard. You really can't change that. So you have to be pretty confident in how the irrevocable trust is drafted. And I think there are ways to add flexibility if needed. But the benefit of the irrevocable trust is no one really can change it. It's typically creditor protected, and the benefit of creditor protection also typically includes ex-spouses. So sometimes I would work with families where we would set up a revocable trust and they say, I love my son, but I don't love his wife, and I'm a little worried. And so something I would suggest is, and I jokingly called it a form of premarital planning that your kids didn't have to do, or, a post-nup that your kids didn't have to enter into. It would be an irrevocable trust. So when the parents pass away, everything that would go to the son would be held in this irrevocable trust for the son's benefit. The son could be the trustee of the trust. They can make distributions from the trust for their health, education, maintenance, and support. Those are pretty standard terms. But the beauty was, because he didn't own them, the trust owned the assets. Creditors typically can't go after those assets. So there are some pros and cons of setting up those trusts for sure.
Yeah. Great. And on that topic, you mentioned that usually these trusts are set up to be bequeathed to someone, right?
Mm-hmm.
And what if I am not having children?
Mm-hmm.
How might I think about this differently? And then obviously we'll ask about having children as well, but
Sure.
Yeah.
I honestly think it's important. Obviously, when you have kids, you want to take care of your kids, but it's a very simple decision when you have kids. When you're going through estate planning, you're like, oh, yeah, I want everything to go to my kids. And then you just figure out the best way to leave assets to your kids. When you don't have kids, it's kind of like the world's your oyster. You can name it, you can leave it to whomever you want. And so when you're thinking through that, I think identifying who you want those assets to go to, whether it's your parents, your partner, your friends, your sibling, and then figuring out the best way for the assets to go to them. So you may have a sibling who you love dearly, but they are terrible with money. And you're like, I want to take care of you. I want you to inherit, some of my estate, but I don't want you to be in charge of it. So you can set up a irrevocable trust for that sibling, and then name someone else to manage it. I often saw that with, clients who wanted to take care of their parents, and their parents were older. And so parents couldn't really manage the assets, but the kids were like, I'm already kind of supporting them, and I want to make sure they have enough assets should something happen to me. So I'm going to leave, a specific amount of money or a certain percentage of the estate, or all of it, whatever the case may be, for the benefit of my parents in trust. And then if they pass away, it goes to my siblings, or it goes to my friends, or charity, whatever the case may be. So I think identifying who you want the assets to go to, and you don't have to, and I'm assuming you guys know this, but just in case you don't have to leave everything to one person. There's so many ways you can leave assets from your estate. You can leave a specific bequest. You can say, oh, I'm going to give, $20,000 to my friend. and then the balance will go to someone else. Or you could say, I'm going to leave a percentage of, or a piece of real property. You can say, I want our family beach house to go to my sister, but the rest is going to go to my partner. Whatever the case may be, you can really make the estate plan your own. You get to decide how assets are distributed, and there's a lot of options there. So just be mindful that, it's not like you have to pick one person and roll with it. It can be a whole number of people.
Yeah. And on that point too, even on the other side, right, the creation of an estate plan, do you find that people are often creating estate plans together? And like, maybe this is kind of leading into the parental angle, right? Yeah, maybe you can speak a little bit to that.
So, when someone is married or they have a partner, oftentimes they'll work with the same attorney to create, an estate plan that either mirrors each other or they work alongside each other. Sometimes you'll have situations where one spouse decides, everything's pretty much separate property. I maintain this. This was when I want to keep this separate. So they'll have their own counsel, but I would suggest if, you're in a situation like that, that the attorneys talk to each other so there's no surprises. But you want the estate plans to work together, whether you are leaving assets to your partner or your spouse or to someone else. But having those conversations, and it can be uncomfortable. It totally can be uncomfortable. My poor husband, I talk about it all the time with him. He's like, I don't care. I'm like, no, but you need to care. So we're in the process of updating our estate plan. But having that conversation of, okay, so if I pass away, do you I love you, but I want to make sure my half of the estate when you pass away goes to our kids. So I might leave those assets in an irrevocable trust for your benefit. So we have that protection in case you later get married. Or you can say, spouse, I just want to keep it simple for you. I'm just saying when I pass away, everything just goes to you outright and you can kind of just control it. There's all sorts of things to think about, but I think having that conversation early on before you start the estate planning process of what your intentions are is very important.
Yeah, and Janelle early on asked a really challenging and related question, right? Which is, caring for aging parents as well. Yeah. She says, any tips on how to share navigating trusts and wills with them, especially when folks are in high conflict? And should multi-sibling families know the details of a trust for an elderly parent once it's complete? I think what we're doing here is sort of looking ahead to how can we support parents who may not be well-versed in this space.
That can be a really difficult conversation because your parents are used to taking care of you, right? And so when you tell them, we need to get your affairs in order, sometimes that can be met with a little bit of resistance, but I often find that explaining to the parents, I just want to make sure that you're taken care of if something were to happen, that I can be in charge and I don't have to go to court and become a conservator. I can just immediately step in and take care of things for you. That often can be a good, breaking or starting off point. But making sure your parents have an estate plan is really a gift to you and your siblings because you're avoiding having to deal, your parents are saying where they want their assets to go. In a high conflict situation where, your siblings may not get along or sometimes I see kids that kind of disappear for a while and then all of a sudden they're back in the parent's life right before they pass away. I think and every family is different, but I personally am of the opinion that it can be helpful for the parent if it's comfortable to lay the groundwork and say, this is how I want my estate plan set out. And you can choose to respect it, or if you have a problem with it, tell me now, because we should be addressing this earlier rather than later. They don't want their, kids to be fighting when they pass away. So having a conversation of like giving a lay of the land to the family can be really beneficial. And then there, when the parents do pass away, if there are questions or there are arguments, you can just say, we had this whole conversation with mom and dad. You should have addressed it when they were alive. And, that can kind of extinguish some of those arguments.
It's really tough.
Yeah, it is.
I watched a friend go through a lot of contentious family stuff, like their mother went through it. I'm floored and flabbergasted. I want to believe that something like that could never happen in my own kind of family. And then I'm certain that, I don't know what I don't know, right?
Yeah. And it's interesting because I would, work with families. And I feel like the older generation sometimes they're a little bit more locked up when it comes to talking about money and where assets are going to go or anything like that. They don't, because their parents didn't talk about it, and so they don't talk about it. But if framing it as, I want to take care of you, because you do, can head off some of those conversations. But I've dealt with clients where they've said, no, I don't want to talk to my kids about this, and then they pass away, and I would deal with sisters who would get upset about, the most random things. Like there was one family where they were inheriting millions, but they were arguing over their mom's silk hangers. And that was like the thing that they could not let go. Who was supposed to get the silk hangers? That actually brings up another point that I didn't think to bring up. There's something in an estate plan called tangible personal property memorandum, and it identifies specific assets you want to go to, like tangible assets that you want to go to beneficiaries. That can head off, issues like, the hangers. It can, you can identify specific beneficiaries you want to receive your wedding ring, your watches, your, anything like that. My grandfather was an estate planning attorney, and they had friends in the family. My uncle.
Yeah, I was gonna say.
Yeah, apple doesn't far fall from the tree. But my grandmother, they had one in their estate plan, and my grandmother left her old briefcase to me, which was totally falling apart. But I was the first female attorney in the family, and she was really proud of me. And she used to work for the FBI. And so this was her briefcase when she worked for the FBI. And so she wanted to give it to me. And I still, it's worth absolutely nothing. It's falling apart, like monetarily, but emotionally, like I love it. And so you can even identify tangible assets that are of emotional value. So you can head off some of those arguments if needed.
I love that.
Mm-hmm.
We have an audience question. Mindy, would you like to ask?
Yeah, thank you so much, Lizzie. You mentioned that we can set up trusts for beneficiaries who are not great with money. And I was wondering, how does that look like in terms of setting them up for success when we pass? Like, does it go to a financial advisor of sorts who manages the trust, and then they kind of have predetermined guidelines for when funds can be withdrawn or cannot be withdrawn? Or I was just curious how that looks like.
You can set it up any which way. So I have set up irrevocable trust for beneficiaries where they get all income, but any distributions of principal is tied to education and maintenance and support. And then the trustee, whoever that might be, it could be a family friend, it could be a sibling, it could be a corporate trustee or private fiduciary. There are people that are in the business of just being trustees of trusts, and Banks often can serve as corporate trustee and help, administer the estate. It really depends on the family dynamic. Sometimes, you are like, oh, my kids get along. Siblings okay to serve as trustee. They'll just work it out. And then other times you'll see where the parents are like, my son's going to have a hard time if his sister is going to be the trustee of his trust. So we're going to name a corporate trustee or private fiduciary to manage it. So it's not up to her. We want to preserve that family relationship. And so the trust could say, everything's discretionary to the trustee. Trustee can make distributions based on what they believe the beneficiary needs, or beneficiary could be entitled to income, or they can be entitled to a certain percentage of the trust each year. I've worked with families where they say, I'm only going to give 5% of the income or 5% of the trust assets to the beneficiary each year, in a way to kind of slow the progression of the assets being distributed to them. So it really just depends on the situation. Just know that there's a lot of options.
Thank you so much. That was really helpful.
Sure.
Thanks, Lizzie, for everything that you're sharing. I'm processing. Specifically, what's in my mind is what we went through as a family. Unfortunately, my dad didn't have a will, so there was the probate. It took 3.5 years. 2020, so just really messy, right? So there's 4 of us. I would be the executor of my mom, who's still living, estate. I know that, and was able to get her to do the thing, sell the extra house, get with an attorney. But since there's already the contention that was left over from dad, like my siblings don't even talk to me. And I was like a silent partner in all this, like I was just the chosen one. So should I be able to read that trust that my mom put together? Because I still to this day have no clue what's in it. I know the attorney, I chose them for mom and so forth, but anticipating, kind of what could happen and what was going on with dad, it's like, ugh, I cringe.
Yeah. I really hope you don't have to worry about anything when the time comes. I totally get it. I think if you're going to be the successor trustee of the trust and your mom feels comfortable, you absolutely should read the trust, because you need to know what you're getting yourself into. Sometimes it could be that you review it and you're like, this is too messy. Like I will step in if my mom is incapacitated. I will take care of her. But when the time comes, I might resign and name someone else, because I just don't want to deal with it. And I don't want to be responsible for anything that my siblings may come after me for. But I think it can be really helpful to review a copy to the extent your mom allows you to, obviously, because you want to kind of know what you're getting yourself into. Good luck. Oh, yeah. It's not fun.
Vani, go for it.
Hi, nice to meet you all. It's my first session that I'm joining. A couple of questions. I think in the like pre-event survey sort of thing, there was a question about how much wealth, if I'm thinking about the right, how it may vary depending on your levels. Is there anything like after a certain amount of assets, the plan should change, or like does it vary a lot based on your amount? And also another question, which may not be related, but like, are there tax implications of all this?
Yes, there is. There's always taxes. So just kind of a brief overview. There is a federal estate tax exemption. That is the amount that each of us can pass gift and estate tax free. Right now, it's 13.99 million. I don't know why they didn't just round it up, but it's 13.99 million. It's scheduled to go up under the One Big Beautiful Bill Act to 15 million starting in 2026. That is the highest the estate tax exemption has ever been. Just for reference, I think it was 20 years ago, I was looking at some numbers about a week ago. 20 years ago was 2 million. So to go from 2 million to 15 is a pretty big jump. Anything above, so each of us has 15 million, or soon we'll have 15 million. Anything above that amount is taxed at 40%. which is a pretty significant number. And then beyond that, there are some states that have estate tax. So New York, there's, I believe, 12 or 13 states that have estate tax or inheritance tax. Connecticut, New York, Washington, Oregon, there's several others. And so you have to be mindful of that. And so that, whether your estate is going to be subject to estate tax, can change your estate plan. So, for example, if I have a client that's in Washington, just like for context, their estate tax rates are graduated and they top out at 35%. So not only are you paying estate tax from the state estate level, then you have to worry about federal estate tax too. So a huge chunk of your estate, there's an offset, but a huge chunk of your estate could go to taxes. So for a client that is in Washington, Oregon, whatever state may have estate tax, you might consider the estate plan to say, if I'm married and if I pass away, I'm going to have my half of the estate go in an irrevocable trust for the benefit of my surviving spouse. And I'm going to allocate my exemption to that trust. So that way, when my spouse passes away, those assets that are mine pass estate tax free to the next generation. Some states, you have to allocate it to an irrevocable trust in order to preserve it. So that would certainly dictate where assets go. The other thing that taxes may come into it is, let's say you have a child that does really well for themselves. There's something called GST tax and GST trust. These are irrevocable trusts that you transfer or that you set up during your lifetime or when you pass away. And the benefit of these GST trusts is that the estate plan, this trust is for the child's benefit, but when they pass away, the assets aren't subject to estate tax. So they may have their own estate. And let's say you set up a trust for them with a couple $1 million, and over their lifetime, it grows to 10 million. I'm just making up numbers. All that 10 million is outside their estate, is not subject to estate tax when they pass away. So you have to think about forward thinking. Obviously, if you're young, you don't know what the future holds for your kids, but as you get older, you may update your estate plan to think through what your kids' potential estates are. And you have to think about your own estate tax and structuring the estate plan in the most tax advantageous manner. Beyond that, there's also something called a step up in basis. So when someone passes away, anything that you own when you pass away, with the exception of some assets like retirement accounts, which are tax deferred, most of your assets will get a step up in basis. So when that can be great from a capital gains perspective for your beneficiaries. Just thinking, my husband works for a tech company. We have a lot of stock that was, when we purchased it at like nothing. And now it's gone up in value. And so if something, gosh, this is so morbid, if something were to happen to him, it would get a step up in basis. And so for capital gains purposes, I would only pay capital gains on the difference between what it was valued at when he passed away and then whatever I sell it for versus what we purchased the stock for and whatever I sell it for. So that is something else that plays into it. It could be that you have, I've worked with families where they have, kids from a prior marriage, or they really want to make sure their assets are protected. You want to take care of your spouse, but you want to make sure those assets go to your children when you pass away. You can, think through, okay, do I want to preserve assets for estate tax purposes? Or, combined, we have 30 million and we're under that exemption. So maybe we make an election for that irrevocable trust. So when my spouse passes away, those assets get another step up in basis. So there's all sorts of things that an attorney can do where a good attorney is going to focus on what makes sense for you. Estate tax preservation, or getting a second income tax adjustment when, your spouse passes away. I should caveat, for the income tax adjustment when a spouse passes away, it has to be assets that the spouse actually owns. It can't be assets that are, your own separate property. Those don't get a step up in basis. It would be the assets that the spouse owns.
Diana, go for it.
Hey, Lindsay, you mentioned about, not having to give evenly to everyone. So take,
Mhm.
for example, in the case of multiple children, and I know it's a very personal question, but what's a framework and what's a way to think about even distribution versus distribution based on needs? Like, how have you walked through families on divide by, say, if there's 4 children, divide by 4 versus more on a need basis without creating drama or any hard feelings? So
Yeah. Well, the way I look at it is if you were alive, you'd probably be spending more on that, or, using more of your estate on that child that has additional needs. What every family's different. But I have worked with families where a child has special needs, for example, and the parents will leave a larger percentage to that child in a special needs trust that says when that child passes away, anything that's in that trust will go equally amongst his siblings. And so while there may be upfront more that goes to that child, if there's anything left, it gets split amongst the siblings, which kind of softens the blow, so to speak. But at the end of the day, you want to take care of your children. And if one child needs more, I think it's perfectly reasonable to give that child more of a share. Another thing to think about, I sometimes see families where there's a big spread amongst the children. So you could have, for example, my brother is 8 years younger than me. And we, same parents, everything, but we have kind of a big spread between the two of us. In a situation like that, you might consider where the concern isn't necessarily special needs or anything like that, but it's, I've put my older kids through college. If I pass away, I don't want my younger child to have a large portion of their share eaten up by college expenses. You can do something where you can put in your estate plan, to the extent any of my kids haven't graduated college, then they get a certain amount put towards their trust to pay for that college. So it kind of comes off the top. Or you can do something called a common pot trust, where all of the kids are beneficiaries and the trustee can distribute the assets equally, unequally based on the kids' needs. And when the youngest turns a certain age, it just gets split amongst the children. So there's a lot of ways you can cut it. It just depends on, the family's particular concerns.
thank you.
Yeah.
Great. We probably have time for one more question, and then I'll end it with a more action-oriented question. So anyone want to do the honors? Okay, we have one in chat. This one is interesting. So how do you prepare a new deed that transfers ownership to the trust when you have a simple trust with one property? And Jennifer, I'll get to you if we have time.
So whoever set up the revocable trust should also be preparing the grant deed, transferring the property to the trust. It's, it's a pretty simple process. Every state has, I feel like I'm caveating all my answers with every state or every family is different, but it's true with states, there are specific requirements for the state. There are a lot of deed preparation services that you can find online where you provide the address and they look up the current deed, and then you provide them a copy of the trust, or you tell them how you want it distributed, and they will prepare a new grant deed, send it to you. The deed needs to be notarized, and then that can be submitted to the recorder's office. So, but typically the attorney is the one that's preparing the deed to transfer it to the trust. And if you bought a property, so that's for properties that you already own when you set up the trust. Let's say you buy a property after you set up the trust. If you haven't closed yet, you can provide a copy of the certification of trust or trust document to the title company, and they will prepare the deed to transfer to your trust. Or, once, if it's already closed, I would either reach out to your attorney and say, hey, I bought a property, I forgot to put it in the name of the trust. Can you prepare a new deed? Or reach out to one of these title service companies. I hesitate to have anyone prepare their own grant deeds. I've had to go to court several times trying to fix issues later down the line when people don't prepare a deed correctly, and it can be an expensive process. So I think it's better to just pay a little bit more upfront to have it done the right way, because there's also, in addition to the deed, there's often tax statement documents you have to prepare, and sometimes those get lost, or they're not prepared or anything, and then you run into issues.
Great. Jennifer, you have last question, and then I'll wrap it up for us.
Yeah, just for someone who's starting this process, I'd like to get some guidance on what some of the most important topics or things I should be thinking about before meeting an estate planning attorney.
I think this is a great question. The more you think about it in advance, often the cheaper it is, because you're not having to, come up with all this or talk to your attorney about all of this, because, typically they charge by the hour. I think it's important to identify the best fiduciaries for your estate plan, and they don't need to be family members. I really want to encourage you to think about who's going to follow your wishes. I think oftentimes people feel like they have to name siblings, parents, whatever the case, children, whatever the case may be, and that isn't true. If you find someone who's going to follow your healthcare wishes as your healthcare agent, find someone who is really good with money to be the agent under your durable power of attorney and executor of your estate and successor trustee of your trust. I also think it's good to name two people. So have one, have your backup, but then have a backup to that person just in case something happens. And then guardians, there's a few ways to cut it. You can just name one person and say this person is going to be the guardian, and if this person can't be the guardian, then someone else will be the guardian. Or you can say, I'm going to name this married couple as the guardians, but then if you're going to do that, you should be mindful of the fact that, let's say they get divorced before you update your estate plan. Do you want the trust to say, in the event they're divorced or someone passes away, then this person's going to be the guardian? It's really something to think about. Even if you name a guardian, typically they're still going to have to go before the family court and get approved as the guardian. If the children are older, then they're going to have a say in whether they want that guardian to be their actual guardian. As they continue to get older, they have more of a say. The judge will get their opinion, but most of the time, whoever you've named as guardian is traditionally going to be respected. Another thing to think about is sometimes I would tell clients to write a letter to their guardians, identifying your wishes and desires with them serving as guardian, what you want the outcome to be for your children. You can also do that with, anyone who's managing assets for your kids, thinking through what makes sense. So to your question, I think figuring out who you want as your fiduciaries is huge. And then beyond that, how you want assets distributed when you pass away. If you have minors or kids that are under in California, it's 18, who are going to inherit assets, I would highly recommend that assets go to them in trust, and it can be held in trust for their lifetime. It can be held in trust until they turn a certain age. You can even have a trust say, when the child turns 25, they get 25 or 50% of the trust. And when they turn 30 or 35, they get the balance. You can kind of bifurcate the distributions. I kind of like that approach, because if the beneficiary makes mistakes, they're not, using all of their inheritance, they're using a portion of their inheritance. So that's also something to consider. Just identifying who the fiduciaries are and identifying who the beneficiaries are, and the best way to leave those assets to them. So, those are things you should talk to your attorney about, but if you have a general idea of what you want, it can definitely save you some time and money.
Wow, this was incredibly helpful. The questions in the chat started firing up just towards the end, and it's like, oh, we don't have time, and I still have like 12 action-oriented questions to ask you. But I think I want to be respectful of everyone's time. I think the one thing I will ask is, what is the immediate first step that you recommend for people now that they know a little bit about this topic to get the process started?
Think through those three, who's going to be in charge, who the beneficiaries will be, and how, you're thinking through how they will inherit, whether it's like a cash bequest, whether it's a percentage of your estate. You can talk through the finer points with your attorney, but I think identifying that is a great step. And then finding an attorney that you feel comfortable with is also huge, because I know that until I went in-house, I would work with clients and I'd see them, some clients I'd see every year because they'd change their mind on how they wanted assets distributed, or I'd see them every few years. My rule of thumb has always been review your estate plan every 3 to 5 years. You'll probably be making adjustments every 5 to 10 years, unless you really want to make changes, whether that's because, your relationship with the fiduciaries might change, kind of see, you may have left assets to your parents and they've passed away, or you may have left assets to your kids and it said outright at age 25, and you're thinking, there's no way my child should be inheriting these assets at age 25, whatever that may be. But I think finding an attorney that you trust, that you can work with in the long run, is also huge.
Yeah. And final question, just so people don't get taken for a ride, how much should they be expecting?
Oh gosh.
I hate this question, but it'll vary over time. I know this.
It will vary over time, and it will vary where you're located. So, I work in San Francisco. It's expensive in San Francisco because overhead's expensive, and so fees tend to be a little bit higher. Whereas if you went outside San Francisco to some of the, edges of the Bay Area, it might be cheaper. And you don't necessarily need to work with someone who's kind of in the big city. There are good estate planners that aren't in a big city that will do a great job. And it also varies by state. So again, San Francisco, very expensive in California and very expensive in San Francisco. Whereas, someone I work with in Washington may pay $1,500, and I've worked with clients that have done their estate plan in Sacramento and it's $2,500, and in San Francisco it might be $5,000. So again, it really just varies on where you're located. The other thing is, it may be that your estate plan is going to be even more expensive because you're making a lot of revisions to the estate plan. And that's where the idea of thinking through it ahead of time really will benefit you, because the more revisions you make, often that means it will get expensive because they charge by the hour. The attorney will charge by the hour. So that also can be a factor. But, just in terms of San Francisco, I would charge, and our firm was my firm was a fabulous firm, but we didn't have big overhead compared to large firms. And we would charge, and this was a couple of years ago, but anywhere between $6,000 to $10,000 for a standard estate plan. And if you needed additional things, it would just increase from there. Whereas, like I said, I'm working with a client right now who is working with someone in Sacramento who's wonderful, and they're charging $2,500. So it really just is dependent on where the attorney is located.
Fantastic, Lizzie. Thank you so much for giving us such an insightful crash course on this topic. Really, really difficult one, and you handled it with empathy, with care. I think it's just so refreshing to be held, frankly, through this topic. It's a really tough one, but also, like I said at the beginning, a big part of our financial strategy now as well, potentially. So let's start this process, and maybe we'll do another one on it. If people have more questions, we can follow up. And please do stay in touch, everyone. Look forward to hearing how this goes in the future. Lizzie, thank you again.
Thank you. Thank you. Hopefully, you know, people got something out of this. Thank you.